might as well go ahead and get started. We'll call the meeting to order, and we do have a quorum present. We'll take care of the official business first, and then we'll go down through the approval of agenda and minutes. This meeting is being held pursuant to and in compliance with the continuity of government ordinance or an ordinance to effectuate change in certain deadlines and to modify public meeting and public hearing practices and procedures to address continuity of operations associated with COVID-19 pandemic, adopted April 28th, 2020 by the Orange County Board of Supervisors in accordance with Virginia Code 15.2-143. This meeting is accessible by https://www.youtube.com/channel UCNLEM-LGRXY DFKCPIOJOQ. All that information is located on Orange County website. Look on the Planning Division or Planning Commission, and you will see that information. This information is conducted remotely, and there will be no physical public access. During this meeting, there will be no opportunity for the public to comment. Can I have the approval of agenda, and if someone wants to add anything?
Mr. Chairman?
Yes, ma'am.
I would just like to note that for your public hearing matter, this is the continuation of both the SAR Substantial Accord Review Public Hearing 2101 and SUP 20-05. Thank
you. So we'll add A and I guess A1.
Well, they're concurrent. I think you need to have, when you get to the point of making recommendations and formulating motions, they'll need to be handled separately, with the substantial accord review matter preceding any sort of vote on the special use permit. But I think we had listed them previously as one item and two, concurrent hearings on our prior agenda.
Okay, for this agenda, we'll make the substantial accord 1A, and this one, the continuation of SUP 20-05. We'll just make that B, just for agenda purposes only, so that we know we have to handle them separately. So just for agenda purposes only, we'll do A, and then we'll do B, and we can let them stay on the previous format as they are. But I have been told that we have to make sure we have distinct, different motions for them. Is there any other additions to the agenda? Okay, so we need to add one in here right before reports. So I guess that would be item number 8, and then reports would be item number 9, and then change the numbers as we go down. And myself, Mr. Lansing and Mr. Gillespie we're all going to chat about how we move forward with the actions of the Planning Commission meeting, virtual or in person, and or a combination thereof, and the state of emergency that's coming up, so we can make that necessary. What do we want to call it, Eric?
Are you asking how I would explain the situation with regard to meeting electronically?
Right. What do we want to call that? Electronic meeting, or just something for the agenda?
Just an agenda title. I think I would call it something like determination of location for future meetings.
Okay.
How does that sound?
That's for me.
You can call it whatever you want, but
yeah.
if you're asking for a suggestion, that's mine.
Yeah. All right. With those two changes, can we have the approval of the agenda unless there's others?
So moved.
Is there a second?
I'll second it, Mr. Chairman.
District 5 moved it. District 1 seconded. All in favor, say aye.
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 All opposed, nay. Okay. That's our agenda for tonight, folks. Solicit a motion to approve our minutes from the last meeting or the previous meeting.
So moved, Mr. Chairman.
Second.
So moved by District 5, second by District 2. All in favor, say aye.
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 All opposed, I'm sorry. All opposed. Agenda and the minutes are approved. No new business, so we'll move right into the public hearing. And the first public hearing and information would be the supplemental accord, substantial accord. And Sandra, would you go ahead first with that, or is Josh taking it?
It will be Sandra. Sandra, you will need to take yourself microphone on.
Thank you. Yes, I had begun to talk. Sorry for not unmuting. Mr. Chairman and Commissioners, we don't have any additional information related to the substantial accord review beyond what was discussed at your meeting on April 1st. We didn't receive any public comments specifically, related to this review for consistency with the county's comprehensive plan. It's staff's recommendation and view that the proposal is consistent with language in our comprehensive plan, and we would recommend that you find accordingly.
Is there any questions in reference to the substantial accord that is we are in compliance with the comp plan as it relates to solar? Sandra, I have one question if no one else does. The solar comes under utilities part of the comp plan, but solar is not specifically listed in the comp plan. Is that the way you understand it?
Yes, sir.
Okay. My fellow commissioners, I asked what action do you want to take? Do we agree with the staff or do we not? A motion would be appropriate.
Chairman Brooks,
Yes.
so I guess this is the motion for the 2232 review. Is that correct?
That's correct.
Okay. So I'd like to make a motion that this particular project is in accordance with Code Section 15.2-2232 of the Code of Virginia, and that it's in substantial accord with the Orange County Comprehensive Plan.
I'll second that.
It's been moved and second by moved by District 1, second by District 5. Any other comments or questions for discussion before we go to vote? All in favor of the motion, say aye.
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 Aye. All opposed, say nay.
Aye.
Nay.
So we have,
Mr. Chair, I think that's going to need a roll call vote.
you think it's going to need a roll call?
That is going to need a roll call vote.
Okay. Roll call, please.
All right, Mr. Capel,
Aye.
Mr. Yancey,
Aye.
Mr. Brooks,
Aye.
Ms. Zellmaker,
Nay.
and Mr. Hutchison.
Aye.
So the motion carries on a vote of 3 aye to 2 nay.
Okay, thank you so much. Sandra, since you're talking, continue on with continuation of SUP 20-05 Redfish Solar Partners LLC has applied for special use permit to construct and operate a solar generation facility on vacant property located on Catharpin Road in the Locust Grove Mine area. The property is zoned agriculture and is identified tax map 50-4 containing 48.29 and 50-4A containing 48.29 acres. The property situated agriculture 2 recommended future land use category as described in Orange County Comprehensive Plan as required by Code of Virginia 15.2 to 2232. And the public hearing is required to determine whether the location, character, and extent of the proposed local facility is in substantial accord with the Orange County Comprehensive Plan prior to any approval of special use for the facility. The second half of that, I would just basically say covers what we've already done.
Yes, sir.
Call from VA.
All right, robocall.
Are we ready? Ready to?
Yeah, we're ready. Trust me, I know how that feels. I gotta cut my answers off.
Okay.
Somebody wants me to get a hearing aid.
The public comment period had closed on this matter prior to your last regular meeting. So the outstanding issue, or one of the main outstanding issue prior to your taking action and formulating a recommendation to the Board of Supervisors was to consider potential conditions that would be attached to this special use permit. There had been a set of proposed conditions included in the original staff report on this matter. Following the first meeting at which that report was presented, you had requested that staff have discussion with the applicants regarding, those conditions. We came back with some proposed revisions, and the commissioners have also discussed some potential conditions that they have advanced. So the list of conditions that was presented in the April 28th memo included in your agenda package was a reflection of staff's understanding of all the prior discussion and various considerations. And to a degree also, as I know the commissioners had considered public comments, there was consideration given to some of the public comments as well. This week, following the publication, of the agenda package, the applicants contacted me to discuss 2 of the conditions specifically, and those were the second under the buffering / environmental category, and the 4th under that in that same category. So I will address the easiest one first, which was a recommendation that compression mats be used during construction. The applicants had explained, as I'm sure they have before, that there is not very much, if any, grading, contemplated during construction. The compression mats would be very costly, and it would just seem to be an unnecessary requirement. So given that response from them and some other input, the staff agrees that recommended condition that was included in the April 28th memo could be struck without causing any harm to the site or the surrounding area. I think the matter which is the one that, at least from the staff's perspective at this moment in time, will need the most discussion was the one requiring perimeter buffering around the site. And we had looked at the last meeting at some graphic representations, which we had understood to be, reflect a buffer of 35 feet along, a vegetated buffer of 35 feet along the road frontage, which did appear to be adequate to screen the project from the road. The objections that I received this week were not to the width, but to the requirement that this buffer requirement be applied to the entire perimeter of the property. So staff did take that under consideration, and the planning services staff jointly reviewed the requirement, re-examined and reevaluated the existing vegetation on and near the property. And it did appear, of course, that there is a fair amount of buffering in place, vegetated buffering in place around the property, but we did note that some of that existing vegetation is not actually on the property where the project is to be situated. We are aware, and that's particularly true, I think, on the western property boundary. Most of the planting that's in place now is on the adjacent property, which we do understand to be owned by the same owner as the proposed project site. But, of course, there's no guarantee that that property will remain in that ownership. So that means there's no guarantee that the trees that are there at this present time would remain. So out of concern for protecting the view shed for all of the adjacent property owners, we have now proposed, and I apologize that it came so late this week, but we are now proposing a vegetative buffer that would be a minimum of 50 feet in width, that would consist of native trees and shrubs, at least 50% of which should be evergreen trees, and that buffer would be maintained on the property, or where it is not present shall be established and maintained on the property. We are proposing that the buffer shall be such that the property or the project would be really completely shielded from view along Catharpin Road. And we are proposing that the adequacy of the buffer, suitability of the buffer would be evaluated and approved by the zoning administrator during site plan review. And the language precluding or preventing any clearing, tree removal, or other disturbance is the same that was already there. So I just presenting, as I said, I apologize that this hadn't come to you in writing, sooner, but that is the staff recommendation at this point in time after further review of the situation on the property. We are aware that the applicant had, expressed before to us as well as in meetings that, there is some concern about, shading of the installation, and they may, I imagine they will want to comment on this if you're inclined to entertain additional comments from them. I do believe I saw an email just before the meeting started that they are prepared to do another, and I don't know the extent of the presentation. It appeared that there might be another presentation.
Okay, does anyone have any questions for staff?
Sandra, have we received any comments on the new conditions from the applicant?
Yes.
What are those?
They are disappointed and feel that we've kind of backed up from where we had been previously in our understanding of their needs is to allow the project to go forward. So they, I feel sure they might like to address that question in person if you wish. But yes, I did receive an email just as I was signing in that they, of course, are very disappointed in this new recommendation.
And the disappointment is founded on what premise? That we were going to use the existing buffer from the adjacent property. Now they got to use their own buffer, or what was your understanding? I know they're listening, but what was your understanding?
Well, I think that was part of it. I mean, I skimmed through the email. I wouldn't really want to put words in their mouths without going back and reviewing the email. I mean, I do think that is part of it, that there is some buffering in place now, and it is located, or a part of it is located on property owned by the Mayos, from whom they are leasing the land for the project.
Okay. Any other questions for staff?
Yes, Mr. Chairman, may I be at liberty to read you their response?
Oh, we've got it. If you want to read it, you can. I can't tell you what you can't read, but the necessity is not there.
I'd like for it to be on record. And it says specifically, this is very unfortunate given the work we have done to discriminate the adequacy of our screening. Such a condition would be economically unviable for a project of this size, and we simply cannot accept such a condition. End of period.
Okay. Is there anything else you want to say or ask?
There's a lot I want to say, but I don't think this is appropriate time. I'll wait for later.
Okay. Is there any other questions for staff?
Yeah, Mr. Chairman, one question. What is
Yes.
what is staff jointly reevaluated? What does that mean exactly? Is that everyone on the staff, or were there?
Josh Gillespie, our
Okay.
director, Tracy, and I.
Okay, so the whole staff.
The whole staff, yes.
Got it. Okay.
Okay, any other questions? All right, I understand that Redfish does have a presentation. We're not going to revisit this complete SUP again. We will talk about the conditions, and we want you to be as brief as possible. I know you do have a presentation, but
Well, yes, sir. I'm sorry if I may. We were just going to go through the conditions that we had discussed previously, and the only two conditions that we had previously discussed that we had issues were the two that Ms. Thornton had just ran through. So I don't know if you want to open and discuss.
Okay, I appreciate that, but let me finish, because it's not only you listening, there are others listening too. So let me finish what I was going to say, because we don't want to. We want to limit you to 15, 20 minutes in your presentation. And rebuttal or your disagreement. What I would like for you to do is that point out the things that you do not agree with and why, more so than going back over everything that we already all agree on. Go ahead, please state your name and go ahead, please.
Yes, hey, how you doing? Jeff Matron with EDF Renewables. I'm here with my colleague Doug Harton and our environmental consultants Tess McMorris and Chris Wu from ECT. If I could just share the screen, I was just going to quickly run through. Okay. So Redfish Solars is a wholly owned entity of EDF Renewables Distributed Solutions. We're the applicant of the project on behalf of the property owners, Mr. and Mrs. Michael Mayo Jr. and their son, Michael Mayo III. The proposed location is 2 parcels of land on the north side of Catharpin Road in Locust Grove, Virginia. The anticipated project footprint is less than 35 acres. The capacity of the proposed project is 4.9 megawatts alternating current, which is a small project as compared to others.
Sorry,
proposed.
Jeff, I don't, do you have your screen shared? I don't have your screen. The
We
others
don't have the
Jeff's
screen, but
Sorry.
Yeah.
Do you know?
Hey, Jeff, I'm
Sorry.
gonna recommend that we really jump into the conditions here
Okay,
based
right.
on the chairman's recommendation there.
There shall be one primary access point on the Catharpin Road. Construction traffic shall utilize
Jeff,
east.
I'm not gonna stop you, but we have that.
Yeah.
Let's get to the conditions, my friend.
Well, these are the conditions, the proposed conditions that we received thus far.
Okay.
So I mean, we
Yeah,
could just get to,
so,
we could get to the two that we discussed that we had issue with. Other than that, we're willing to accept the other conditions as they were sent to us. It's up to the commissioners. How you'd
Yeah.
like to proceed.
I believe that we are largely just down to the buffering condition, which I think Mr. Yancey had read the beginning of my email, but I would encourage those on the commission to read the remainder of my email for additional context, because that is obviously very important. It's important to remember that context that we are now, I think, 7 months into this process with the commission. And I think this condition that has been presented here tonight at this point in the process is actually more onerous than the condition that we went through the effort of rebutting through demonstrating the adequacy of screening, refining that screening based on the recommendations of county staff, and actually presenting those results of that finding, those simulations, et cetera, to the commission. And I believe that was actually incredibly well received by the commission as well. So yes, it's incredibly disappointing for us to come upon a condition that would literally kill a project at such a time in the process. So I apologize if that email came off too harsh or unwelcomed, but that is not at all the intent. I just did not mean to mince words or convey something inaccurately, because that would truly destroy the project and kill any opportunity here. I would also point out that the conditions to date have been written to be specific to the perimeter of the subject property, which extends well beyond the project area. And we would ask that a future condition or whatever condition be imposed actually not apply to the entire project or the property, considering that the property owner has gone through the effort of actually clearing much of the property himself. And I don't think that he would be particularly happy if we had to go back in and plant in the areas of which he has recently cleared. And I think he would object to the fact that we'd be planting to screen his own properties from his other property. So I think we would have a number of issues with that, not just from an economic standpoint, but from the landowner standpoint, and also from just the communications we have to date and the work that we've gone through, and I guess the expectation that has been set from those efforts.
Okay, can you hold that point right there and let the commissioners get in if they so desire, so we can take it point by point. And I would ask both the applicant and the commissioners to pause before you speak so that the Zoom can catch up with you so we don't start losing. Does any commissioner have a question or comment based on what they've said so far? Okay, well then I do. I would say just about every project we put forward, every SUP at least, there's some type of buffering that's required. We require that buffering on what I would call subtle things, such as storage facilities, just for protection, and it's listed in the comp plan and the project analysis, just for protection of adjacent property owners and future adjacent property owners. And it's bowed itself out, based on what I can understand, to even enhance the property values around it so that it's not completely open, but it also gives some natural protection and some security protections for projects such as this that's put right in the middle of agricultural from my perspective. So I think for you to say that you don't want to buffer your project it's a little bit disingenuous. It's what part of applying and looking at the guidelines did not think you would have to buffer it? We're sorry that I get what you're saying. Some of it's not your fault, but it's really your responsibility to buffer your project.
Well, I think we are absolutely committed to buffering the project, and that is what we have gone through great efforts to try to demonstrate, that the buffering that we are proposing is adequate for the job that and the goal and the intent of the condition. And actually what we had done was try to meet the intent of the original condition that was proposed to us, which again, I think the new one is arguably more onerous. So we had taken that intent and we had gone through evaluations from sight lines to photo simulations and taken in to account both topography and existing vegetation in providing that analysis, because we are absolutely committed to screening this property, and we understand the importance to our county and the community in which we site in, that we cannot come in here and create negative impact where it is unwelcome, and we try to be a good neighbor. So I am not in any way trying to say we do not want to buffer this property. I 100% want to buffer this project, because that is what helps make a good project, and I enjoy developing good projects. But I will say that we have a substantial existing vegetative buffer along the only property line that abuts a residential property, and that is to the east. And we would commit to leaving that as we have told staff in the past. And I think that actually likely meets this condition. It may, but it has certainly areas of vegetation well over this requirement. It may have some that are slightly less. I can't really say offhand. But there is existing mature vegetation in that area that we will not be cutting. And then the primary the only other property line that abuts anyone other than the Mayos is the road front. And we have certainly paid quite close attention to the road front and how we treat the road front and how we can screen that adequately. So I don't think that we're trying to say we won't buffer it. I am trying to meet the intent of your goals here and trying to provide a good project that isn't providing unnecessary impact to your community in any way, shape, or form.
They'll sell their property just when they're no longer the owners of the property, or lease it to someone else. How would it be buffered then if that person that purchases it decides they want to take down that natural buffer? How would your property be buffered at that point?
Well, so the primary property lines that are impacting neighboring property owners, again, are the road frontage and the western property line, all of which will be buffered on our property, and we have no problem doing. So any new visual, unforeseen visual impact would come from somebody moving into maybe the west side where it's currently farm field owned by the Mayos. And I think at that point, if somebody were to purchase a property with an existing solar field next door and an existing swath of trees, that it would be entirely up to them in terms of how they wanted to handle that situation, meaning they would have it at their will to remove the trees, see a solar field, or they could say, I want to remove some portion of them or none of them. But it would really be at the discretion of the future owner at that point, and they'd be coming into it in a situation where it is an existing thing that they know about and can plan for at that important time, but not something that is coming to them after the fact, which I think is primarily what we try to address with these things. But I will say that if there's a particular portion of vegetation that is important to the county, that we'd be happy to pursue obtaining a vegetative easement to eliminate any cutting of that area. But I'm not, none such thing has been brought up to me, nor do I think we have any abutting properties that are impacted by the west side currently, nor would they be if that were to be removed now. It might become visible by some locations, but I don't think it would become visible to a residential property. But and from like a recollection, I think I might have to revisit to confirm that.
One more question and I'm done with it. Your SUP and your condition that you would agree to states that you will have the property buffered. If the new property owner did what you said, you're in violation of your SUP as it would stand because your property wouldn't be buffered. And they can do what they want on their property, but you still are required to have your property buffered by SUP and the condition that you're agreeing to. So 5 years down the road, they've sold it. Doesn't belong to the Mayos anymore. Your solar farm is not going to be out of operation then, based on what you're saying. So then you would be out of compliance of your SUP. And then when you get out of compliance of your SUP, you can no longer function your solar operation. I think you're working against yourself there to some degree.
Well,
I don't believe.
I think there's maybe a little bit of a miscommunication there, a misunderstanding there. I don't know the particular language that you're referring to that says we're buffering, but I think there are many ways in which a buffer is interpreted, and we don't typically consider a buffer in my industry something that is always vegetated and planted. It can, in many cases, be a setback. So I guess I would need a little bit more context on the exact language that you seem to be referencing. But I will say that it is absolutely our intent to meet the intent of our original condition, and that is what we have spent the last few months on. And we have addressed that through discussions with staff and our understanding of that intent. And if we had been made aware of this issue, then I think we would have been happy to address it at any point in time there. Knowing that there is existing vegetation, from my understanding, based off the area you're describing, I think that we could work with the Mayos to obtain rights to that vegetation to ensure that it does stay for the life of the project, if that were a concern. Again, it's just that we have been working to meet the intent to meet the intent of the condition that was presented to us. So it is not that we are trying to get out of buffering or eliminate buffering. It's that we're trying to meet the intent of the buffering condition that was provided to us. And I think we've done a lot of work. I know we've done a lot of work to do that, but I think we've done so pretty adequately. And I think certainly, at least some of the commission would agree with that.
Thank you. I have no further. Any other commissioners got any questions?
I do, Mr. Chairman.
Go ahead.
I'm just trying to understand the concern here because, usually I'm like Mr. Buffer guy, So the concern here is that the adjacent property owners, the Mayos, who also own the solar farm, who not only own the adjacent lots to the north and the west, but also own the next adjacent lots. They own about over 200 acres in the direction. So the concern is that new owners would come in and would remove the buffers so that the new owners would be looking at the solar farm. Is that the concern? Is that what I'm hearing?
No, sir. No, sir. My concern is that the buffering that they're alleging they're going to use is not on the piece or tract of land that the solar is on. It's another tract outside of what they actually have agreed to or leased out. And so what I'm saying is that, I get your point. Let me finish. My point is that if you buffer your property, you're responsible for the tract of land to be buffered, not to be using something that's owned by somebody else. And when the land becomes leased, and Eric can help us on that, the Mayos kind of give up a lot of their authority on that land, other than the final ownership. I'm not saying I'm for or against. I'm just saying that what I recognize is that the buffer they're intending on using and stating it's not on the track that this solar plant is on.
Well, I mean, that, with all due respect, that happens all the time. I mean, I could give you a lot of examples where we don't even realize particular tracts are parceled and we don't have buffering on the particular parcel. But I'm just trying to understand the concern here. So the concern is that the adjacent property owners would purchase the land from the Mayos and then remove their buffer in between them and the solar farm.
No, that's not what I'm saying. I'm not saying they're going to do it. I'm saying it's possible, then you haven't buffered your property. They have no control of that part of buffering. How about that?
Well, okay. I mean, there's lots of things. Okay. I don't want to argue about it. I've sat here for many years, and it is always interesting, the concerns, you know, and they often don't seem driven by the same set of standards, but you know, it is what it is. I mean, I seriously, you know, it's a lot of things are possible. I think it's nearly 100% unlikely that someone would buy the property next to a solar farm or a million other things that we could talk about and remove their buffers in between their property and that solar farm.
What if nature does it? What if nature does it? What if in the next 10 years nature does it? It's not theirs to probably even go on and put it back.
Okay. A point taken. I'm just, I kind of feel, and I don't want to spend too much time on it. I mean, the applicants have to defend themselves, you know, but it's just, I mean, I kind of agree with them. Like, this would have been something good to know, you know, previously rather than 30 minutes before the meeting. But what I did hear them say is that maybe they could obtain the rights to the adjacent property. And so maybe that's the solution. I mean, if they're saying they're willing to do that, then
it's on their property. Then they've leased that like they've leased the land.
Yeah. Okay.
If
well,
I may,
that would be a solution.
I think there just still seem to be a little bit of a miscommunication. I would just say that I personally have never, and I hope nobody from my team or from the development team here at EDF has conveyed that it is their intent to use vegetation on another property to buffer ours. I believe our intent was to not buffer the adjacent landowner that is our landowner, not that to use his vegetation for our buffering. So I think that's a little bit different. I have not been trying to convey to you that I am relying on somebody else's vegetation. This is something that I have done in the past, and I have secured easements for vegetation on abutting properties in order to ensure that it is not cut. I don't typically lease it. I usually would obtain an easement whereby I'd have the exclusive right to cut it. So he can't cut it, I get to cut it, period. So we can just control that. And I think that's something that we're happy to explore. But of course, that would be more that the issue for that is more about timing. And that, yes, that would have been great to know 3 months ago because I could have that done today. So it's not that I am trying to use the other vegetation. It's that based on the discussions that we've had today with staff and to meet the intent of the petitions what's provided to us previously, that we were not intending to buffer our landowner from his project.
Okay, any other questions, any other commissioner pertaining to that point?
Mr. Yancey wants to.
Mr. Brooks.
Mr. Yancey, go ahead. Go ahead.
I'm not trying to put words in the chairman's mouth, but I believe you're alluding to the fact that I don't think that concerned about the adjacent properties next to the project. I think we were worried about the people that live on that road, number one, and have to travel on it on a daily basis, plus the landowners directly across it from a viewshed standpoint. And that is why I am really perplexed here, to be honest with you. And the reason I'm perplexed is that if these gentlemen had read the comp plan in the beginning, it says it's a 100-foot buffer, period. They proposed a 35-foot buffer. Staff has now, in good faith, thrown a lifeline to them, offering 50-foot, and they basically kicked them in the face and basically said, no, it's not viable financially or marketable. So, somebody tried to come to your rescue and you knocked them to the ground. I don't know about the other commissioners, but right now I'm back to 100 foot and I'm hell bent on it.
I don't think that accurately reflects our response. I think we've gone out of our way to show that we mean to address the view impact from Catharpin Road. I don't know what other impact our project would have on anyone other than someone driving down Catharpin Road. I think we've been very transparent in that. I don't think that's a fair way to summarize what we're proposing.
Gentlemen, I'm finished talking. I'm ready to vote.
Well, hold on.
I'd also just mention that I believe the setbacks used on the buffers and setbacks, I think, used on the plan that were proposed initially and even kind of remain today, I believe those were developed in consultation between our consultant and county staff in determining what the appropriate setback requirements were within the county. I could be wrong about that. I think our consultant may be able to jump in and correct me if I'm wrong, but I'm pretty certain that was the case. So we have been working very closely with staff and actually had our pre-application meeting back in the beginning of October of last year to discuss the requirements, what the plan was, any setbacks associated, and have moved forward, actually, I think in close contact with county staff and actually have found the county to be pretty great to work with and have found it to be a good relationship. So I don't think that that our goals are too much different. I think at this point in time, it's just kind of late in the game change that it is truly, it's not viable for the project. So I'm sorry that I don't get to determine that, but it would kill the project, and that's the reality of it. So, I think we're happy to spend some more time to address it. If the board is not in a position to recommend a favorable action, I think we could secure the rights to additional vegetation if that is what is needed, or proceed with additional conversation with the county staff and how to best address. But it is absolutely in our intent from the start to address the concerns of the county and to do so in coordination with the county, ensure that the county is heard and that we are meeting the intent of those conditions. So I apologize if it has come off as anything other than that.
Okay, thank you so much, Doug. Just hang on just a second. I got one question here that might help and might not help. Josh and Sandra, y'all keyed up because I want to know what's the inadequacy of the buffering that you're requiring. You've heard everybody, you've heard their positions. What makes your condition inadequate? And if nothing, say nothing and justify it. Josh, Sandra, don't left us.
Yeah, I'll start with one thing. I mean, at a zero buffer, or a zero screening, that's essentially the end state without an affirmative buffer. So we're discussing really the adequacy of the buffer. Number one, along Catharpin Road, where there is no vegetation and screening. There's a slight grade elevation, which was illustrated well in their line of sight drawing. So you can see the view perspective of a traveler in a car, and that was done very well. On the western boundary, we have a rough estimate of 10 feet, we think, of vegetated space within the project area. What Mr. Carton is discussing relative to a vegetation buffer on the adjoining property owner would absolutely address the desire to have a project buffer in the control of the project. At this point, there is no project buffer other than a very minimal, like I said, about 2 tree deep, 10 feet on the western buffer. On the western property line.
All right, so my Zoom cutting it out. Go back through that last statement again. There's no what?
So basically on the western property line, there is a very minimal amount of the existing trees on the ground that's in the project area within the parcels of this project. And so, and again, we have two parcels. So I want to be clear, it's the western boundary of the westernmost parcel. And we're identifying that but for some planting, there will be a minimal buffer in place, really inadequate to be a buffer in that location. And so we are recommending to the commission that there be some additional planting on the western side. Mr. Carton has proposed tonight that be done with an easement on the adjoining property. And if that could control it, that would bring it into the property, into the project area. However, that property, as he said, if he had started in the past, we could reference it now as a recorded easement, but to bring it in now and refer to it in this case, it definitely is not something that we have record of. It's not, current. It's not part of the project right now.
Well, it does it not state that the solar farm or many projects, SUPs, have to be buffered, and the standard for the buffering is there, and it doesn't mean part of it, doesn't it mean all of it?
I mean, Mr. Brooks, I agree with you that there's an affirmative requirement in the code and expectation in the plan that buffering shall be provided as needed for any project. And the implication, of course, is that it be a full buffer, that it be whatever buffer is needed to achieve the purpose of the buffer. In this case, they have two fields, and on the round, and some trees in the center of the fields will be removed, but the trees at the perimeter of the two fields are very minimal on the parcels that the project is included for. So, but for that line, there's a lot of vegetation buffer out there, but with that property line, it's not on the project site.
Thank you, Sandra. Do you have anything to add?
No, sir.
Okay, any commissioners got any questions based on that conversation? 5 minutes or less, applicant, 5 minutes or less. Is anyone last words you want to share before we move to decide what we're going to do?
Doug, this is Tess.
I would just, oh yes, please, Tess. I was hoping you would go on.
Hi, good evening, Planning Commission. My name is Tess McMorris. I'm the planner for this project, and we've been in close communication with Sandra and Josh and all county staff through our getting up to this point. And I just wanted to provide some background on some of the comments that I've heard in discussion that.
All right, Tess,
yes.
You're going to have to do it in 5 minutes or less, dear.
Sure. Thank you, sir. So there are currently no standards for solar listed in the comprehensive plan. The 100-foot buffer was a condition suggested by the the Soil and Conservation District. That was a suggestion to staff in their ARC comments received in February, which was when we began addressing the buffer and visibility concerns. And based on the vegetation that's currently around the site, we did, ask for a reduction of the amount of feet of buffer, as it would eat into the project area, that would buildable area essentially, because we're giving so much a buffer and setback to the wetlands and natural features that are on site. So we're limiting ourselves to be as careful as we possibly can, as well as maintaining all of the vegetation surrounding, including the condition that Sandra recalled staying the same, as in no other clearing other than is absolutely necessary for the project development will be done. The next item they're just going to touch on just briefly, I know I'm running out of time here, would be that we have worked with staff through this entire process. Our site plan and all modifications to and up until this point have been done in collaboration with staff and at the direction of the commission and based on the commission's desires. So our collaboration with staff would absolutely continue if this evening you decide that you require more information to make an informed and comprehensive decision. Doug?
And actually, this is Chris Wu,
Yes,
also with
thank you for that.
Oh, sorry, I just wanted to chime
Please, Chris,
in.
please make it quick.
Yes, very quick. And when we had first started this discussion with staff, there was no determination of what that buffer width should be. And they had asked us, based on our solar experience in Virginia, you know, what is an acceptable width? And unfortunately, what we have is a lot of projects locked up in confidentiality. But what we expressed to them is that we have had projects pass with 10-foot buffers next to architecturally significant homes, and that had passed. And that had passed not at the local level, but as well at the level of DHR, the Department of Historic Resources, whose one of their missions is to protect the view sheds of architecturally significant artifacts. So, you know, this was a discussion we had up front. There was never any discussion of 100-foot, and certainly EDF is not trying to circumvent any sort of 100-foot buffer, because as Tessa described, it didn't exist for solar. And that's all I want to contribute. Sorry.
Is there anybody else from your?
If I have just 30 seconds. So I was very happy to have Tess jump in there, because I was going to state that we did consult with staff at the beginning of the project on what the buffer requirements were, and without a solar ordinance in the county, there were no buffering requirements, and we took direction from our close coordination with staff through the process. And I just want to reiterate that the property lines that do impact property owners other than our landowner are the eastern and the southern lines. And the eastern line, we have substantial existing vegetation. And on the southern line, we are proposing a substantial vegetative buffer that we have gone through great lengths to refine and demonstrate the adequacy of. So we would absolutely love the opportunity to provide additional information if needed, or additional project rights or demonstrations. But I hope that our work thus far is not seen as trying to circumvent or to be anything other than good partners with the county.
Any commissioner got a question based on their response? Any commissioner got any comments as we move forward, and/or staff?
I do, Mr. Chairman. So I just want to be clear. I just want to make sure I understand this, because Mr. Yancey said something that was surprising to me. So Mr. Yancey proposed a moratorium on solar at our last meeting because there were no standards for solar. And tonight he's saying that there are standards and that this particular applicant is trying to circumvent them. So it sounds to me like there's a little disconnect there in the presentation and the sort of feigned outrage that I'm hearing from other commissioners. So the fact is that there are no standards. There is no buffering requirement. Is that a true statement to the planning department?
Yes.
No,
I would just like to correct the record, because there was basically an accusation that this applicant was being somehow disingenuous. And I'm just kind of just stunned by some of what I'll call vitriol towards solar and these projects in general. I mean, I'll tell you one thing about solar projects. Yeah. So I just want to hear from the planning department, you know, was there a requirement somewhere in our ordinance for a 100-foot buffer around this project that these applicants have tried to circumvent?
I haven't reviewed the setbacks in the ordinance. That may have been a reference to setbacks. It is correct that as has been discussed at prior meetings, we don't have any specific standards that apply to solar installations, and each application is considered on its own merits, and the specifics of any particular location are evaluated to determine what conditions may be appropriate.
Okay, so the answer is there is no requirement for a 100-foot buffer. Is that right? That one of the commissioners misspoke. Is that correct?
I take issue with that, Mr. Chairman. I can read you where there is a standard that was established in 2017.
Okay, go ahead.
If you will look at what this commission, the Orange County Planning Commission, passed on December the 8th of 2017 unanimously, and also that was passed by the Board of Supervisors on December the, that was December the 8th. The Planning Commission passed it on November the 2nd, 2017. Reads as follows. For the first solar farm we approved, it says, a buffer of at least 50 foot in width shall be maintained around the perimeter of the property, except adjacent to Route 20, which shall be at least 100 foot in width. No clearing, tree removal, other disturbance shall occur within this buffer area, except as necessary to construct the electrical lines needed to connect to the nearby transmission line to the southwestern corner of the property. The portion of the above buffer adjacent to and south of Route 20 shall be supplemented with additional tree plantings in order to adequately obscure visibility of the facility from Route 20 on a year-round basis. Trees shall be native species, and mixture of evergreen and deciduous varieties shall be planted in natural and randomized pattern and shall be at least 8 feet in height at time of planting. That's a standard we've already established.
Whoa, that's a condition on a special use permit. Is that true?
There's no difference between that SUP and the SUP we're talking about.
Well, but that's a different. I mean, you just misstated. That's all. It's fine that you misstated it. You said there was a 100-foot requirement in the comprehensive plan, and so that's not true.
I didn't say that.
So you're relying on a condition on a previous solar plant.
That's the standard, Jason.
Okay, that's fine, but I just want it to be presented correctly. So in the future, I can reference past conditions and we'll all agree that those are the right conditions for any future project.
Well, let me throw another monkey wrench in this. As all of you know, we passed.
Well, I'm just trying to correct the record. That's all. That's all I'm trying to do is figure out what the truth is.
Gentlemen, do me a favor. Gentlemen, do me a favor. Take a big, deep breath. And then what I want you to do is give each one the chance to finish speaking. Then the other can speak. I'll give you the time necessary, but I gotta have you do it that way because you're actually talking over each other. And those of us who are trying to learn cannot, especially this old fat guy.
I apologize, Mr. Chairman.
No apology is necessary. Just a little meeting decorum here. So what I got from that conversation is that there's a standard or a condition that was placed on the previous approved solar facility is where you got your information from, and it is not in the comp plan. The question I would ask staff is, while I'm talking, if this is considered as utilities, what's the buffer for utilities? Because I asked that earlier on in the meeting, and that's the reason I voted in the affirmative for the substantial accord. I was against the substantial accord until I was told by staff that utilities is what governs this. So if we move it from solar and look at utility project, let's say if it's a transfer station, let's say it was, I don't know, whatever utilities we want to put there, would there be a buffer required for them?
Mr. Chair, members of the commission, Sandra stated this very well earlier when she said that special use permits are considered on their own merits for each case. Based on the uses proposed in the case and the site conditions of any particular property or properties subject of the applications. So I would just repeat that again. That is how particularly staff finds that although our comprehensive plan lacks specific language related to utility scale solar energy production facilities, that we still have enough information in the comprehensive plan about land use and land uses, including utility facilities, to determine that the special use permit process is the appropriate process by which to consider this land use, which is generally consistent with our comprehensive plan because it's come to us as a special use permit.
Thank you. Any other commissioners have any comments or questions? Any staff have any comments or questions or statements they need to make at this time? Then I solicit a motion of conclusion of this SUP, suggesting that we either vote it up or we vote it down.
Well, Mr. Chairman, I'd like to make a motion, but it's neither of those. Given that we've sprung this on the given that we've sprung this on the applicants, 30 minutes before this meeting, we've accused them of being disingenuous. I would make a motion that we defer and give them a chance to deal with this buffer. And if they can deal with it and figure out a resolution, then so be it. And if they can't, because what I'm hearing is the issue is the buffer. And what I'm also hearing is that we're not willing to give them a chance to address the issue, even though we've been talking about this for 7 months now. So my motion would be to defer and give them a chance to address the brand new information.
Okay, so the only way we can do that is you're gonna have to put a timeline on your motion that we cannot go beyond the May 20th meeting because the calculation clock says that we're getting ready to run out. So, that's really our informational meeting, but you're gonna have to timeline it because if you don't timeline your motion, it's gonna get out of our hands beyond 100 days.
Mr. Brooks,
Is that not
Chairman
correct,
Brooks.
Eric?
No, but Chairman
Yes.
Brooks, you are correct in the timeline that if the commission does not act within that time by the end of May, essentially before your June meeting, that your 100 days will have come to an end. However, the applicant, and I honestly am not sure who the applicant's actual agent is in this case because they'll have to clearly identify which one is speaking for the applicant. But the applicant can consent to the continuation, but they will need to do that. Otherwise, the commission will have lost their time. So that needs to be very clear tonight. And Eric, Mr. Lansing will need to help us out with, making sure the question is posed properly, that they consent to a deferral for such and such period of time. But you do have that option.
Well, if they consent to it, do we have to have a motion on it?
Well, yes, sir. You'll still have to have the motion to, as Mr. Capel said, send it to a future meeting, whatever meeting that would be.
Okay.
Mr. Gillespie, as I recall from looking at the 100-day deadline in the state code earlier today, I don't recall a provision allowing the applicant to consent. I understand that has been tried and tested and that it has worked. I don't think that's in the state code, is it?
No, I don't believe it's in state code. It's practice.
Okay.
Well, so let me make sure I understand it correctly.
Mr. Chairman, may I ask a question for
Please.
Mr. Lansing? Since we are still operating under the continuity of government provisions related to emergency declaration, does that give any sort of leeway, if you will, regarding the 100 days?
What a fantastic question. I think that's a great question. I can only guess in light of the fact that these continuity of government ordinances have not faced a lot of litigation yet. I think my inclination is to say the continuity of government ordinance is not going to extend our time in this case, because I don't see a connection between the pandemic and the need for the deferral. As with some occasions, Yeah, I think Mr. Gillespie relies on a great wealth of experience in these matters, in deferrals like this. And so,
So can we do
if
this,
the commission is of the mind to defer it, then there's, I guess, not a judicial precedent, but a precedent in practice established that says that this is okay. I wouldn't want to rely on this as though the state code established that the applicant can consent.
Okay, let's do this. I think this would be acceptable. Jason, if you would just continue, you have your motion to continue to the next meeting this month. By then, we will have some time for everybody to put model heads together and decide what we can do. That we're not outside of the 100 days by the second meeting. So let's go to the second meeting, and then the smart heads will get together, and the applicant can decide and make their decision whether they consent or not suggesting anything, but we certainly give everybody a chance to go over the buffering. We give everything there. So Jason, if you would just say we would continue to our next meeting, I think it's the 20th, isn't it?
Yes, sir.
And if you would do that in your motion, Jason, I think it would greatly help.
Sure, Mr. Chairman. I'll make a motion to defer this issue to our next regularly scheduled Planning Commission meeting on May 20th.
Is there a second? Chair, we're seconded just for the purposes of moving forward. It's been seconded. Okay, we don't need a roll call for this, but we'll just call it out. All in favor, say aye.
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 Aye. Aye. All opposed?
Nay.
Nay. So I've got 3, 4, 1 against, missing 1 person. Mr. Yancey, which way did you vote?
I'm sorry, Mr.
Oh, you
Chairman.
locked up?
I said nay.
Okay. So we got 3-2. We'll move it till the 20th. We'll take it up then. Thank you all so much. We want to thank the applicant. We want to thank the commissioners. Sorry if anybody felt any way awkward. It was not our intent. We just got the work of the county to do.
No, thank you very much. None of it was taken as ill will here. Appreciate all of the work from the county and the commission.
Thank you so much. Moving right along. Eric, would you help us with the data location for meeting, or the dealing with the location of meeting based on the continuity of government ordinance running out and or
Yes, Mr. Chairman. Yeah, sure. So as you know, the general rule in Virginia is that you have to have a quorum physically assembled in order for any public body to conduct its business. There are a few exceptions to that, and one exception that we have been relying on is this local ordinance, the Continuity of Government Ordinance, which state law allows us to suspend certain provisions in order to keep government moving forward. And so we've done that. We've actually, amazingly enough, suspended, we have the power from the General Assembly to suspend the provisions that would have prohibited us from meeting without a quorum. But there's an expiration date on that ordinance because it's passed pursuant to emergency legislation, and it will expire at the beginning of June. And that means that all of the authorization that we've been relying on to meet electronically, where all of us are electronic and not just 1 or 2 people dialing in, that authorization is going to come to a close. The General Assembly has been gracious enough to pass its own bill allowing public bodies, including this commission, to start meeting, but it will not go into effect until July 1. This new bill that the General Assembly has passed that would allow us to meet online without a quorum physically assembled. So all that to say, there's a period from the whole period of June, we are not allowed to meet electronically, not without a quorum physically assembled, at least. If 2 commissioners want to come in electronically, that's fine, but at least 3 have to be physically there. So I've talked with Mr. Chairman about that window of time between the expiration of the continuity of government ordinance and the time where this new law goes into effect. And I've discussed that with him. The commission will need to make a determination about what it wants to do, either for the month of June or just for all time moving forward, whether it wants to begin meeting again permanently, or just for the period of June, or how it would like to take that out.
Okay, thank you, Mr. Lansing. I'm suggesting strongly that the commission go ahead and start the meeting in person, and if somebody wants to be out or has to be out for a legit reason, that would be our person out. But I think we need to go ahead and meet in person. I will tell you that listening to the governor's press conference today, he has not even decided that he's going to extend the mask wearing beyond June the 15th when that runs out, because that's attached to the COVID side too, simply because it's illegal in the state of Virginia to wear a mask in a public place if you're an adult without a few exceptions. So if he doesn't do something with, you can't even voluntarily wear the mask. So he's got to do something with that too. And I just want us to go ahead and we're the only body, I'm told, that's not meeting in person for the county. And they're strongly suggesting that we get back in meeting in person and get things done. So I'm hoping we can start that as soon as the May 20th meeting. Let's hear some conversation.
Mr. Chairman, are you aware on the 20th, the Orange County Business and Industry Picnic is scheduled?
I am, but we've already had this in process. I agree with it. It's there, but it's not much I can do about that. That's why I was saying we need to go ahead and just meet back in person, because everything under the sun is going back in person. So if nobody's against, we will have our next meeting in person May the 20th.
Location?
County building. And if there's somebody who needs to be out, we'll hold you with the whatever ordinance we have to hold you with is out, but I can't have any more than, I gotta have 3 there or we won't have a quorum. So we just gotta make sure that that's where it is. You can continue to wear your masks in. We are gonna practice the social distancing. We are gonna make sure things are adequate. And if you feel that you want extra space, if you would let Josh know, he can make provision for you to be down on the floor and not up on the dais.
Mr. Chairman, there are a lot of logistics involved. I do want to note, since Ms. McMorris is still on the call, that one provision that we have not made is for remote participation by anyone other than commission members. And so just any applicants, members of the public, et cetera, would be joining that meeting in person in the room, subject to the CDC guidelines and meeting the protocols.
Right, that's correct.
Mr. Chairman? Mr.
Yes.
Chairman?
Yes.
So which building? So first of all, I'll be there in person. I've gone out and gotten vaccinated, and and assuming we follow the prevailing guidance, the CDC guidance, I think it's fine for those of us who have gotten vaccinated to meet in person. And so I'll be there either way. But the question I have, Mr. Chairman, is which building will we be meeting in? The normal building, or
same place we've been meeting before?
Okay,
we'll go back to the county
building
building, same place we're meeting before, on Main Street.
Okay.
Yes.
Okay.
All right. Moving right along. Mr. Johnson, do you have anything?
The only thing I would say, just kind of follow up on Jason's wondering what building. He may have been wondering if we'd be meeting in the new building, and the new building is not ready yet, so no one's meeting in it. But we are hopefully getting within sight of that new building being operative. We've had a number of issues, very frankly, with the contractor. But the last I heard, they were out there working on the punch list to get that new building started. So hopefully sometime in the next 3 or 4 months, we will be able to hold public meetings in the new space, which there'll be a lot more room there than in the current space, and much enhanced video and audio system.
Thank you so much. Anything else? All right. Mr. Gillespie, we need you now.
Chairman Brooks, thank you. Members of the commission, Mr. Johnson. I had asked for some time, in addition to the director's report, to address 2 special topics and just ask that they be put on the agenda. And I'll say that these are in progress, so these are progress reports. First of all, I'll say I'm about to hit 2 months in my role in the department, and thrilled to be in Orange County. I've learned a lot in that time, thanks to many of you. As we go to in-person, we will distribute the bylaws of the Planning Commission to all the members, and Mr. Johnson, liaison, just to remind you what the adopted rules are as it relates to conduct. Again, this will be, a transition time as we have people meeting for the first time in person with the commission in quite some time. I'm thrilled to say that in the last, since your last meeting, we've published all the case data for all the active cases, zoning, special use permits. We've got another pending application that's been made, and it's not ready for bringing to you yet, but for a private road application. So we're getting all that information posted to the website. And I want to thank a couple folks that helped us out from administration, Allison Simpson, Michelle Williams, and our own Tracy Newman in Planning and Development Services, who got all that information out there. So I encourage you to check it out. I'll send you the link to that again. That does include, for a short period of time, next week or 2, we will keep posted the current case that I want to bring to your attention for SUP 2004, which is Mountain View Rehabilitation. And that case was withdrawn earlier within the last week. And so we've noted that on the website. That's a withdrawn case. As is custom and practice in Orange County, it's recognized by the commission at their next meeting that a case has been withdrawn. So I'm hereby recognizing and bringing to your attention that that case was withdrawn. As we go into the summer, it's a busy time for planning, development, and construction. So, we're keeping all the bases covered, making sure we continue to have good coverage for high levels of customer service that are expected in Orange County. But we're also looking at special projects. So on the utility scale, solar energy facilities, I just want to note on a couple fronts. Orange County has joined the Rural Solar Development Coalition, or RSDC. This is a coalition of counties in Virginia that are rural. It's grown to about 18 to 20 members in the last year and a half. It grew out of the Virginia Association of Counties Committee on Energy and the Environment. And as that group was meeting, the rural counties specifically were part of a working group that included some other localities, including cities. And there was a recognition that there would be help to each other, from each other across the state. So been in contact with the coalition, and Chairman Crozier on the board was the initial point of contact and has had great information that we received from some of our peers across the state. We've also been approached in our income consultation, at least the beginning of a consultation with the Virginia Department of Mines, Minerals, and Energy. There's a national program called the Soul Smart program, and it's basically an education program for communities to be able to be aware of different practices as well as codes and ordinances. And there are about 400 Soul Smart communities across the nation. And we will be suggesting that we consider that program. Of course, we did receive a project scoping and a proposal from a consultant for a special program for Orange County about a month ago. That would be a 4 to 6 month undertaking where we would endeavor to end up with changes to the comprehensive plan and to zoning ordinance, development standards, policies, anything else that would come out of that. 3-phase project, research and discovery, comprehensive plan and zoning ordinance amendments, and concluding with presentations to the Planning Commission and Board of Supervisors. And in that consultant's experience, it was advised that last part be in a joint meeting format, which Orange County has a good tradition of joint meetings of the Board of Supervisors and the Planning Commission. So we think, number one, that's a good model, and number two, that's a good model for this subject area. Of course, we received a lot of comments from interested citizens, including folks from the Virginia Farm Bureau, with specific points that they want the county to consider in any application of a solar energy production facility or in a solar ordinance or policy. So that really covers the utility scale solar energy facilities. I'll be happy to answer any questions on that particular item.
Mr. Gillespie?
Yes, sir.
Could you go back to the consulting firm? The consulting firm was hired to do what?
No, so Mr. Capel, you may remember about a month and a half ago, I think I'd been on the job 2 weeks, maybe 3. And we were asked to come up with a framework for what comprehensive plan and zoning ordinance amendments would look like, how long that would take, what it might cost, basically what the effort and undertaking would entail. And so we reached out to a consultant to give us basically a scope of work, a scoping proposal, basically, and a project proposal. We did not hire them. We merely asked them to give us, again, an outline of work and a proposal, which they did, but we've not hired anyone.
So is that just for the solar ordinance, or is that broader than the solar?
Yes, sir, Commissioner Capel, that is specific to solar as a land use being treated within the comprehensive plan and the zoning ordinance.
Got it. Okay, so it is that. So you sent like some sort of RFP out to them?
No, it was specifically to a company that has performed about 15 or 20 of those undertakings in Virginia and another 15 or 20 outside Virginia. So we talked about the scoping on the phone. I had the 1, 2, 3 steps I just outlined made sense to me. That would be what I would expect the scope to be. And they provided us a little more detailed backup to what the scope steps would entail. And then an order of magnitude cost, which I reported to you all at $20,000. So, that was just information gathering. We did not issue a request for proposals.
Okay, got it.
Mr. Gillespie,
Thank
has
you.
this been coordinated with the Board of Supervisors as well?
I would say at a 1-to-1 level only. I mean, and Mr. Johnson shaking his head.
No, this has not been coordinated with the Board of Supervisors. I'll leave it at that.
Thanks, Mark.
And Mr. Gillespie, could you repeat what is the name of the? I know you talked about this on our agenda phone call, but what was the name of that consortium again?
It's the Rural Solar Development Consortium Coalition.
Okay, and could you was there? I know the answer to this, but could you, for the public's and the record, was there a fee to join that?
Yes, there is a fee, and we took it out of our operating funds from the department.
Okay, and how much was that?
It's $5,000.
$5,000. And took it out of the operating funds for the department. Is that normally how these things happen?
Right, for memberships and subscriptions.
Okay. And was that coordinated with the board?
No, I was in contact with a member of the board administration.
Okay. So that's, in all told, that's 25, could be 25, 5,000 we've spent so far, and potentially another 20,000 if we were to hire this consulting firm. Is that correct?
I mean, that's the tally of two costs. You'll remember I did not recommend hiring a consultant when I presented that information to you.
Oh, yeah, I just think it's important for people to know. I just want it on the record that we're actually spending dollars on this. That's all. And it's not, I'm not poking you at all, Mr. Gillespie. I just want everyone to know the money that we're talking about.
Is there any other questions? Anybody else has any questions? Okay, you got number 2 on there, don't you?
I do, Mr. Chairman. Again, this is a progress report. I would like to say that we have more definite material to bring to you, but I'll say at this point, again, this was generated in part by some inquiries from members of the board, Mr. Johnson, and some private folks interested in exploring what the current policy is and what some alternatives might be. In Orange County, we refer to multiple dwellings on a parcel for residential use, not in a farm setting, as an accessory apartment. And the origins for the accessory apartment relate to garage apartments, basement apartments, basically what people would consider to be an apartment. But the way that the use is permitted in Orange County now, we have detached 2 buildings on one property, so 2 units, and the standard term, the industry term, or the planning term for that is an accessory dwelling unit, or an ADU. So accessory dwelling units in places that have issues with affordable housing, both urban, rural, and suburban, all are grappling with accessory dwelling units and what those may be. A granny flat, a mother-in-law suite, the college kid who lives in the back while they're in school, whatever it may be. And so we came at it from a little different perspective, which was to realize that we had a very limiting number, which is, as I put on the agenda here, an 800 square foot maximum for accessory apartments. But again, to kind of highlight the differences between Orange County and Alexandria, for example, an 800 square foot limit on accessory apartments in the city of Alexandria may be perfectly appropriate, but sort of get lost in the landscape in certain areas of Orange County. So in doing some research, one of the key principles that I found that I think is most important is to look at the 2 dwellings on one parcel as something that could stand alone. And this is the approach taken in Culpeper County. In Culpeper County, if, for example, they had the same zoning to allow 2-acre lots, then a 4-acre lot that could be divided into 2 2-acre lots that have the same or that meet the minimum requirements for road frontage, lot area, building setbacks, everything that would allow those lots to stand alone at some future date is the prerequisite to have a second dwelling on a lot. So that's one approach. I think there's a lot of value, however, to the 800 square foot accessory apartments, whatever that threshold is, that would never be able to meet the road frontage requirements, the lot area requirements, because it's behind the house or beside the house or somewhere located in a place that makes sense relative to the primary building. And you're not talking about a situation of 2 buildings, 2 houses side by side. So, that's my initial findings. Looked in some other localities. There is some survey that's been done out there that I can begin to bring you some more tables. But again, the Orange County experience is coming from a place of accessory apartments. And I would differentiate the accessory apartment that we have and think that actually has value to keep it from the accessory dwelling units concept and the idea that units in future be able to stand on their own. Again, just ideas and I think some key principles in other localities.
Josh, I would prefer for my personal point is that if you put that in writing as it would look in the comp plan and or the zoning ordinances, wherever it belongs, and let us see it from that angle. That way we'll know exactly what we're voting on and participating in. And then you can cite the counties which you looked upon to get some comps, if you would.
Yes, sir.
Do you have anything else?
Nope.
Okay. Commissioner comments. We're going to start at Commissioner 1 and go down the numbers as we have them. Mr. Capel, start, please.
I don't have any comments, Mr. Chairman. Thank you.
Thank you. Mr. Yancey, start, please.
I have no comments, Mr. Chairman.
The chair has no comments. Mrs. Zellmaker, go ahead, please.
I have no comments.
Okay, Mr. Hutchison, go ahead, please.
Just one comment for Josh. Will you be dealing with a grandfather clause on that? I could understand new permits and that kind of stuff, but there may be existing locations that that already are being used, and I don't know how you would deal with enforcement.
Mr. Hutchison, are you asking about the 800 square foot
Yes.
Accessory apartments?
Yes.
Sure. So like I said, I think right now some value is to keep the language for the 800 square foot accessory apartments the way it is, because that allows one type of accessory dwelling, which is an accessory apartment, and then to have another category for those properties that are larger. And the citizen that came to us with that concept in mind, that his proposal was that only for properties 4 acres or greater that they have the ability to have the second dwelling unit larger than 800 square feet. We would go further and say that we think you probably should create it in such a way that the parcel could be cut off at a future time and made to stand alone without creating a building setback or a zoning setback violation or some other nonconformity that doesn't meet code.
Similar to what Culpeper's doing.
Yes, sir.
Okay.
Okay, if there are no more commissioner comments, the next meeting is May the 20th. We will be meeting in person in the Gordon Building on Main Street. I'll solicit a motion to adjourn.
So moved.
Is there a second?
Second.
It's been moved and seconded. We adjourn. All in favor, say aye.
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 All opposed? Thank you all so much for your attention and your time, and we'll see you on the 20th, if not before.